Peace, love, and prosperity to all of humanity. AMPAG Media is back with the continuation of the France versus USA, or United States of America case that took place in 1952 at the International Court of Justice. We left off with the fourth contention, which was page 24. In addition to this particular document, we'll also be going over a correspondence on extraterritorial jurisdiction between the French ambassador and the United States Secretary of State. We went over that on Sunday. We didn't finish it. We will finish it. We'll attempt to finish it today, and we'll discuss a few more of the topics, such as American legation, something that I'm sure many of you may not have heard of. And I certainly know I never heard of it, but there's a lot that we haven't heard of until we started studying international law. These things aren't discussed in school on no level. Well, I can't say no level, but the higher education perhaps. But this information is necessary for even lower education, starting at middle school. This is middle school information. This is basic information. This is basic history and law that we all should be aware of, especially Moors, and definitely coming out of the Moorish Science Temple of America or the Moorish movement in general. And this is not the information that we receive. What we receive is municipal laws, general history. I'm tired of the history. You already know the history. The next question after we learn the history and we get to come to the understanding of who we are, the next understanding would be, where do we go from there, right? The history is more suited for the NBCs who are just coming into the knowledge. Once you're in the knowledge, we should be going into the next degrees of understanding, which is establishing governments. That was the whole purpose in what that's the whole system in which that the Prophet created or put together, established back in 1913. Bring you back into the understanding of self, to then move on into the aspects of running government, to reestablish the empire. Because during his time, he came right at the time during the fracture of the empire. It's fascinating how Allah, the breath of Allah, presented the Prophet, and during the times of turmoil in the empire, and it still went on for the next 100 years. But that was all by divine timing, because in that process, the Sultan became the king of Morocco, the kingdom in Al-Kibulan, and in doing so, he left the empire open for the Moors to come back and reestablish their governments. In fact, between him and the United States, they together made an attempt to, what's the word I'm looking for? Remove, if you will, Article 15 of the Treaty of Madrid. We'll be talking about that one of these Sundays. Anyhow, to continue with the reading, we're on the fourth contention. The fourth contention of the United States is that and by the way, this is the judges of the ICJ speaking. The fourth contention of the United States is that the extensive consular jurisdiction as it existed in Morocco in the year 1880 was recognized and confirmed by the provisions of the Madrid Convention, and that the United States, as a party to that convention, the United States is a party to that convention, thereby acquired an autonomous right to the exercise of such jurisdiction. So they're autonomous. How did they acquire that autonomous right? We'll find out, I suppose. To the exercise of such jurisdiction, independently of the operation of the most favored nation clauses. So that's how they were able to establish it. There can be no doubt that the exercise of consular jurisdiction in Morocco in the year 1880 was general, or that the convention presupposed the existence of such jurisdiction. It dealt with the special position of proteges and contained provisions for their exercise of jurisdiction with regard to them. On the other hand, it is equally clear that there were no provisions of the convention which expressly brought about a confirmation of the then existing system of consular jurisdiction or its establishment as an independent and autonomous right. The purposes and objects of this convention were stated in its preamble in the following words: the necessity of establishing on fixed and uniform basis the exercise of the right of protection in Morocco and of settling certain questions connected therewith. In these circumstances, by the way, you all, next Sunday, we'll be going back over the Madrid Convention of 1880. Could you put that on the calendar, brother Hakeem? We'll be going over that next Sunday. We already went over it, but we'll go over it again. It's going to make more sense now that we go over it, especially after reading over this case. It's been 4 or 5 weeks since we went over it. I think it would be good to go over it again. And then we also will go back over the act about the series, but we're not going to read the whole thing. We're just going to pick specific articles since we've already covered that one as well. Okay, but I think that this one is important to go over the Madrid Convention. In these circumstances, the court cannot adopt a construction by implication of the provisions of the Madrid Convention, which would go beyond the scope of its declared purposes and objects. Further, this contention would involve radical changes and additions to the provisions of the convention. The court, in its opinion, interpretation of peace treaties, second phase, ICJ report 1950, page 229, stated, it is the duty of the court to interpret the treaties, not to revise them. All right, so they interpret treaties when they adjudicate the cases. They deal with the treaties. Treaties is supreme law of the land. Secondarily, it would be any other form of international law, but no other form of international law trumps the treaties. I had a grand sheik tell me that divine law trumps treaty law. Okay, I don't know anywhere in history or nowhere in current history, including the United States Constitution, that states that divine law is the supreme law of the land. Treaties are the supreme law of the land. And by the way, treaties are divine laws. But the divine law that he's referring to is the Circle 7. And he's basically saying that nothing supersedes the Circle 7. Well, what's the problem with the Moroccan Temple of America? Why haven't they used the Circle 7 to overthrow the government through diplomatic means with the use of law? These Moors are off the chain. The fifth contention of the United States, and I've already established in the same Circle 7, which he claims to be the law, that, let's do it again, paragraph 4, page 67, the Moroccan Temple of America is a lawfully chartered and incorporated organization. Organizations can't make moves against states. Come on, let's not be incompetent. Let's reach our level of competency. This is why we're considered minors or minorities. Minorities has absolutely nothing to do with numbers. 10 of us, 20 of them, right? And it has nothing to do with race or anything of that matter. It's the mental state and the mental capacity of the people. Minors, minority. We need to raise our degrees into adulthood, the level of majority, right? Major thinking versus minor thinking. Major thinking is when you're talking about international law, governments, government operations, treaties, things of that nature. And all the Moors and AMPAG are raising up to that degree. I'm grateful for that. All right, let's continue. The fifth contention of the United States is that the consular jurisdiction in Morocco was recognized and confirmed by various provisions of the Act of Judgement, and that the United States acquired an autonomous right to exercise such jurisdiction independently of the operation of the most favored nation clause. In 1906, can someone please mute their mic, please? Someone's mic is unmuted and you can hear your back. In 1906, the 12 powers at Tangiers. What are the 12 powers? You know, we'll go over it again. Not all of them, but the ones that I could remember. Great Britain, Germany, Russia, France, United States. Those are the ones that matter. Netherlands, Hungary, etc. In 1906, the 12 powers at Algeciras all exercised capitulatory rights and privileges to the extent that they were prescribed either by the General Treaty with Great Britain of 1856 or by the Spanish Treaty of 1861. They did so by virtue of direct treaty grant, as in the case of Great Britain or Spain, or by virtue of most favored nation clauses, as in the case of the United States, or without treaty rights, but with the consent or acquiescence of Morocco. That's it. It's all about our acquiescence. Let's read that again. They did so by virtue of direct treaty grant, as in the case of Great Britain or Spain, or by virtue of most favored nation clauses, as in the case of the United States, or without treaty rights. So they didn't even they don't have the treaty rights, but they have, but with the consent or acquiescence of Morocco. This is what's given them their authority, our acquiescence. And they pointed it out, as in the case of certain other states. Accordingly, the Act of Algeciras presupposed the existence of the regime of capitulations, including the rights of consular jurisdiction, and many of its provisions assigned particular functions to the then existing consular tribunals. Reference has been made in the course of the argument to Articles 19, 23, 24, 25, 29, 45, 59, 80, 81, 87, 91, 101, 102, and 119. All those references was made out of the Act of Algeciras. 102 states that, if I can remember it off the top of my head, 102 states that a consular jurisdiction can be imposed upon foreigners as well as Moorish subjects through Sharifian jurisdiction. That's what 102 says. Penalties, fines, and confiscations upon colonizers or upon foreigners through consular court. That's Article 102. And then it goes on to say, and Moorish subjects through Sharifian authority. Sharifian jurisdiction. Sharifian jurisdiction meaning the Sharifian governments. Same thing as consular jurisdiction. For example, Chapter 5, which deals with the customs of the empire and the repression of fraud and smuggling, contains Article 102, which provides every confiscation, fine, or penalty must be imposed on foreigners by consular jurisdiction. I guess I remembered it a little bit, right? And on Moorish subjects by Sharifian jurisdiction. Article 102. Every confiscation, fine, or penalty must be imposed on foreigners by consular jurisdiction and on Moorish subjects by Sharifian jurisdiction. So, Moorish Americans are under the jurisdiction of Sharifian jurisdiction and consular jurisdiction because Moorish Americans are Moorish subjects. If you cannot prove your protections from another state, and what is the proof? Your emanating documents. What are your emanating documents? Your state ID, your passport, your certificate of live birth, whatever that's been issued to you by the state. Example, a Brazilian can show you his state ID from Brazil, his birth certificate from Brazil, his passport from Brazil. These are the emanating documents that show and proves his allegiance to a different state under which he falls under protection, which is their particular states. Moors can't do that. If you can't do that, then you're a Moorish, ipso Joe Moorish subject. In the condition, and that's just the way it is all around planet Earth. Why are we so special that all we have to do is say it, and that's just is what it is? Clearly, that hasn't been working for the past 100 years. And the times that it has worked with your little writs and affidavits, those were arbitrary type of decisions and it's not duplicatable because the next Moor that come in behind you may not be able to pull it off. Maybe you got a certain swag. Maybe you got a certain thing about you that the judge liked. Maybe the judge was treated well by his wife the night before. And then the next morning might come across a judge that was treated horribly by his wife the night before. And he just throw the book at you. I mean, it's arbitrary. We gotta put their backs on against the wall with law, in which meaning that they cannot use arbitrary measures to adjudicate cases. They have to go strictly by the law. These are the things that they tend to do. All these 1Z, 2Z's victories is not sufficient for more. And the victories that we're gaining in these tribunals is nothing. What are we talking about? Traffic tickets. What, mortgages, child support. That's nothing in comparison to forcing decolonization and taking over the entire system and settling the entire matter across the board versus little circumstances or little subject matters here and there that has nothing to do with the overall picture, which is you establishing your states. In the conditions which existed at the time, the article made it necessary for the prosecution of nationals of the 12 powers for fraud and smuggling to be dealt with in the consular courts. So it all gets dealt with in consular court. That is the ultimate venue. Consular court is the supreme court of the land. And what does consular court use as the supreme court of the land to adjudicate against foreigners? Treaties, which is the supreme law of the land. Since 1937, the position has been one in which 11 of the powers have abandoned their capitulatory privileges. So since 1937, the position has been one in which 11. So who's left? We just said 12, right? Further up here, it said 1906. In 1906, the 12 powers at Algeciras all exercised capitulatory rights and privileges. Down here, it says, since 1937, the position has been one in which 11 of the powers have abandoned their capitulatory privileges, and their consular jurisdiction has ceased to exist. Well, who's left? We'll find out, in case you guys haven't already figured it out. Accordingly, Morocco has been able to make laws and to provide for the trial and punishment of offenders who are nationals of these 11 countries. The position of the United States is different and must now be examined. Why? Because the United States is the only other power that's left. And also, as I was reading that, something hit me and I lost my train of thought that quickly. It'll come back. Unlike the Madrid Convention, the Act of Algeciras was general in its scope and was not confined to a limited problem such as that of protection. On the other hand, the interpretation of the provisions of the Act must take into account its purposes, which are set forth in the preamble in the following words. Let's go over the preamble. Something hit me earlier. Since 1937, the position has been one in which 11 and the consular jurisdiction has ceased to exist. I read something that caused me to think of something, and now I forgot that thought. I lost that thought. That's fine. Okay, so what are the words or the preamble? Inspired by the interest attaching itself, let me highlight it. Inspired by the interest attaching itself to the reign of order, peace, and prosperity in Morocco. That's what hit me. Okay, so when I mentioned earlier about the Sultan becoming king of the kingdom in Al-Kibilan, and I also said, through that statement, I was saying that he left the empire open for our Moorish states to come back online. Guess what else happened? I'll tell you what else happened. All the loans that caused the empire to be indebted to the European states, all those loans have disappeared as well. It went with the king, which means that we come into this thing debt free. What can I say about that? In fact, we come into this with them owing us. Everything happened in divine time. And so it's just really a matter of us putting this thing together and exercising our authority. Inspired by the interest attaching itself to the reign of order, peace, and prosperity in Morocco, and recognizing that the attainment thereof can only be effected by means of the introduction of reforms based upon the triple principle of this sovereignty and independence. Let's go with this one. Let's highlight this instead. Triple principle of the sovereignty and independence of His Majesty the Sultan, the integrity of his domains, and economic liberty without any inequality. Currently, AMPAG is operating on the second principle, which is, and really AMPAG and New Mecca as well, which is integrity of domains. We've already established sovereignty and independence. Sovereignty and independence is the establishment of your state. Integrity of domains is the integrity or the establishing of your laws to protect your infrastructure of your state. And then economic liberty without any inequality is when they start paying their taxes, duties, tributes, rent, according to the Treaty of Peace and Friendship. Neither the articles to which reference has been made above, and this is where a brother asked me about, well, what about our economic situation in the state? It comes on the third principle. This is why we have to understand the triple principles. We can't think that coming into the government, we're operating economically. We're utilizing their system, which is our system, but we're utilizing their system temporarily until we establish economic liberty without any inequality. And by law, by international law, they have to assist. Go back to the charter, chapter, I remember the chapter, but it's Article 73, Part B, in which it's basically says that colonizing states must assist indigenous people in the establishment of their states, their cultural, political aspirations, etc., as they go through their various stages of advancement, right? And that's where we're at, going through our various stages of advancement on our land that they have colonized and took over our system. So therefore, we have to, in order to force decolonization, we first establish our government. Obviously, we will continue operating within the system until we get to the point to where we can force them into economic liberty without any inequality, meaning that they now have been softened up through various judicial orders from consular court to finally start paying their rent or taxes. And that really is when we take back the system as a whole, right? So we take back the system as a whole, and that takeover or reclamation equates to economic liberty without any inequality. It's already set up. The public works and what was it called? What's the other one? Public works and I forgot the other one, but public works and all that stuff is already set up. To include, what was that?
Public services.
Public services. There you go. Public services and public works is already established. And the bidding of for the contracts from other nationalities, all that stuff is already established. I mean, they have already established everything in conformity with the treaties, which we were supposed to do. So all I can say about this is, thank you, colonizers. All we got to do now is just take it back and operate it. Why reinvent the wheel when we can just govern the wheel? Neither the articles to which reference has been made above, nor any other provisions of the Act of Algeciras purport to establish consular jurisdiction or to confirm the rights or privileges of the regime of capitulations which were then in existence. The question, therefore, is whether the establishment or confirmation of such jurisdiction or privileges can be based upon the implied intentions of the parties to the Act as indicated by its provisions. An interpretation by implication from the provisions of the Act establishing or confirming consular jurisdiction would involve a transformation of the then existing treaty rights of most of the 12 powers into new and autonomous rights based upon the Act. When they say the Act, obviously they're talking about the Act of Algeciras. It would change treaty rights of the powers, some of them terminable at short notice, e.g. those of the United States, which were terminable by 12 months, notice, right? So within, you know, we can terminate with a 12-month notice. I mean, I really, please, anyone who's out there watching these videos, and I haven't been saying this in the previous classes because I'm not a YouTuber, I'm not in with all that. Please subscribe, like, and I ain't with all that. But I will say this: please share this video. Please do, and share AMPAG videos as well. Because goodness gracious, we over here stressing over these people, and we can terminate their contract with a 12-month notice.
Question. I'm terminating the contract within 12-month notice. Is that once the notice goes out, is it a complete done deal, or can it be arbitrated, modified, or suspended, or anything like that between that 12-month period when notice is given?
It's a done deal. The only thing that they could do is appeal. Appeal the judgment through consular court. And if they don't like the decision that consular court comes with, which is probably still to reaffirm the termination, then they can take it to the ICJ, and they're going to lose there as well, because that's in the contract. That's in the 1830s. That's the difference between 1787 and the 1836 Treaty of Peace and Friendship. That they have 12, that we, or even they could terminate it themselves with the 12-month notice, but they ain't going to do that. But yeah, once that notice has been presented, and after their appeal, which they would lose the appeal, there's nothing else. It's over with. They must pack up and leave. Does that answer your question?
It does. But then my mind says, what if they are belligerent and don't want to, and want to start a fight, a war?
I mean, they can be belligerent right now and just start a war. We can't worry about the negative aspect of it. We just got to know that we have that authority and put it on them.
Right.
Yeah, I mean, they could attempt so, but I mean, it would still be against the law, and they would just be making it. It would just be making it worse for themselves.
That they would.
Yeah, that's against the law anyway. They can't impede. They can't encroach upon our state. That's called just cogence. They'll be violating just cogence or preemptory laws. So that's one mindset that we have to get away from. What if, or what could or would they possibly do? I don't care about what they may. All I care about is what it is that we're gonna do. You know, that's how we got to approach this thing. What is it that we gonna do? Can't worry about what they gonna do or not do. You know. You're
right. Because I'm tired of worrying about them.
Yeah, exactly. That's what I keep trying to tell you, Mother Makara. How you doing anyway?
I'm fine.
All right. So 12-month notice. Inter rights enjoyable for an unlimited period by the powers and incapable of being terminated or modified by Morocco. We could even modify it. Let me read that over. Those of the United States which were terminable by 12-month notice, inter rights are enjoyable for an unlimited period by the powers, which they're not going to have that, and incapable of being terminated or modified by Morocco. See, Morocco has the authority. We can modify it if we like. Neither the preparatory work nor the preamble gives the least indication of any such intention. The court finds itself unable to imply so fundamental a change in the character of the then existing treaty rights as would be involved in the acceptance of this contention. There is, however, another aspect of this problem arising out of the particular articles to which reference has been made above. These are the articles which include provisions necessarily involving the exercise of consular jurisdiction. In this case, there is a clear indication of the intention of the parties to the extent that certain matters are to be dealt with by the consular tribunals. And to this extent, it is possible to interpret the provisions of the Act as establishing or confirming the exercise of consular jurisdiction for these limited purposes. The maintenance of consular jurisdiction, insofar as it may be necessary to give effect to these specific provisions, can therefore be justified as based upon the necessary intendment of the provisions of the Act. This result is confirmed by the provisions of Article 10 and 16 of the Convention between Great Britain and France of July 29, 1937. These articles refer to the jurisdictional privileges accorded on the basis of existing treaties or enjoyed by the United States of America under treaties at present in force. They propose, therefore, that the jurisdictional privileges of the United States, even after the surrender of British capitulatory rights, even after the surrender, because remember, they exist on a charter through Great Britain. So these presupposed, therefore, that the jurisdictional privileges of the United States, even after the surrender of British capitulatory rights, would not be limited to the jurisdiction provided by Article 20 and 21 of the Treaty with Morocco of 1836. This view is also supported by the provisions of Article 4 of the Protocol of Signatures to this convention. This article provided for the abrogation of certain provisions of the General Treaty of 1856, and as regards the Act of Algeciras, for the renunciation of the right to rely upon Articles 1 to 50, 54 to 65, 70, 71, all provisions Article 72 after the word permit, 75, 76, 80, 87, 101, 102, 104, 113 to 119. And it also provided that in Article 8, does that say 8 or 81? I guess 81. The words by the competent consular authority must be deemed to be omitted. And in Article 91, the word competent must henceforth be substituted for the word consular. It is clear that in 1937, France, representing Morocco, and Great Britain were proceeding upon the assumption that certain of the provisions of the Act of Algeciras recognized a limited consular jurisdiction for the purpose of the judicial proceedings therein described. The court is not called upon to examine the particular articles of the Act of Algeciras which are involved. It considers it sufficient to state as its opinion that the consular jurisdiction of the United States continues to exist to the extent that may be necessary to render effective those provisions of the Act of Algeciras, which depend on the existence of consular jurisdiction. This interpretation of the Act, in some instances, leads to results which may not appear to be entirely satisfactory, but that is an unavoidable consequence of the manner in which the Algeciras Conference dealt with the question of consular jurisdiction. The court cannot, by way of interpretation, derive from the Act a general rule as to full consular jurisdiction, which it does not contain, right? The court cannot, by way of interpretation, derive from the Act a general rule as to full consular jurisdiction, which it does not contain. On the other hand, the court cannot disregard particular provisions involving a limited resort to consular jurisdiction, which are, in fact, contained in the Act and which are still in force as far as the relations between the United States and Morocco are concerned. Subject matter switches when you see that one star? No. When you see 3 stars is when it switches, you see only 1 asterisk. I forgot what that means. Jay Bay was explaining that to us because that's how he writes his documents in conformity with the same structure that was established by the ICJ. Okay, so the 6th contention of the United States is that its consular jurisdiction and other capitulatory rights in Morocco are founded upon custom and usage. So they're just used to doing what they've been doing, right, for the past 200 years. This contention has been developed in 2 different ways. The first relates to custom and usage preceding the abandonment of capitulatory rights in the French zone by Great Britain in 1937. The second relates to the practice since that date, dealing first with the period of 150 years, 1787 to 1937. Has anyone read that letter from the Pope to Obama, where they were crazy about that, going crazy about this back in a couple of years ago?
Yes, I definitely read it.
Okay, so do you remember what she said? Something about 150 years. She mentioned something about 150 years. She mentioned something about going back 150 years from the beginning of something. I forgot what she was supposed to be what the Pope.
When you're talking about the lawyer that voted for the Pope.
Right. She mentioned,
yeah.
I have to go back and refresh. It just hit me when I read this. She mentioned something about 150 years. So what she was referring to is between 1787 and to 1937. 1937 being the year in which Great Britain had relinquished their extraterritorial jurisdiction. Dealing first with the period of 150 years, 1787 to 1937, there are two considerations which prevent the acceptance of this contention. The first is that throughout this whole period, the United States consular jurisdiction was in fact based not on custom and usage, but on treaty rights. At all stages, it was based on the provisions either of the Treaty of 1787 or of the Treaty of 1836, together with the provisions of treaties concluded by Morocco with other powers, especially with Great Britain and Spain, invoked by virtue of the most favored nation clauses. This was the case not merely of the United States, but of most of the countries whose nationals were trading in Morocco. It is true that Morocco was just split up in a bunch of pieces, and they just, the sultans allowed all types of foreigners here to do trade. That's what all these treaties are about. It's about amity and commerce. It's about trade, peace and trade in Morocco. It is true that there were powers represented at the Conference of Madrid in 1880 and at Algeciras in 1906, which had no treaty rights, but were exercising consular jurisdiction with the consent or acquiescence of Morocco. Let me read this again. It is true that there were powers represented at the Conference of Madrid in 1880 and at Algeciras in 1906, which had no treaty rights. None, nil, zero, nada, not a treaty right in existence, right? But they still were exercising consular jurisdiction. Why? Because the Moors acquiesced. So we just left it wide open for everybody else to do whatever it is that they wanted to do. It is also true that France, after the institution, we have to understand that this is so important to understand. And fast forward to 2022, up until now, up until the existence of AMPAG, New Mecca, and AMPAG, and those who are coming online, up until then, we still were acquiesced. Unbeknownst to us, for ignorance of law, there's no excuse. And also it's been done so by design. Because I can assure you that many of these grand sheiky supreme guys and supreme grand governor leader guys knew these principles and were blocking Moors in exchange for a check and 501c3 tax exemptions. In other words, they traded the entire estate for crumbs. So when people like Cujo L want to attack dirty Moors, do some research on your grand sheiky guys and your grand governor guys and talk to them, because they got you in a trick bag. It is also true that France, after the institution of the protectorate, obtained declarations of renunciation from a large number of other states which were in a similar position. This is not enough to establish that the states exercising consular jurisdiction in pursuance of treaty rights enjoyed, in addition, an independent title thereto based on custom or usage. The second consideration relates to the question of proof. This court in the asylum case, ICJ report 1950. Could you please mute your mics, please? Pages 276 and 277, when dealing with the question of the establishment of a local custom peculiar to Latin American states, said the party which relies on a custom of this kind must prove that this custom is established in such a manner that it has become binding on the other party. The Colombian government must prove that the rule invoked by it is in accordance with a constant and uniform usage practiced by the states in question, and that this usage is the expression of a right appertaining to the state granting asylum and a duty incumbent on the territorial state with a capital S. This follows from Article 38 of the Statute of the Court, which refers to international custom as evidence of a general practice accepted as law, right? In the present case, there has not been sufficient evidence to enable the court to reach a conclusion that a right to the right to exercise consular jurisdiction founded upon custom or usage has been established in such a manner that it has become binding on Morocco. But see, when they say on Morocco, who is Morocco? I mean, you know, the land is one thing, but what makes up Morocco? The people. So I can reword this and say, in the present case, there has not been sufficient evidence to enable the court to reach a conclusion that a right to exercise consular jurisdiction founded upon custom or usage has been established in such a manner that it has become binding on the Moors. I can say that too, or the Moroccans. This convention has also been based upon the practice since the date when the treaty right of the United States to exercise extended consular jurisdiction and derivative rights came to an end with the coming into operation of the convention between France and Great Britain of 1937. During this period, France and the United States were in negotiation with regard to a number of questions, including the renunciation of capitulatory rights. There are isolated expressions to be found in the diplomatic correspondence, which it considered without regard to their consent, with their context, might be regarded a acknowledgement of the United States claims to exercise consular jurisdiction and other capitulatory rights. On the other hand, the court cannot ignore the general tenor of the correspondence, which indicates that at all times, France and the United States were looking for a solution based upon mutual agreement and that neither party intended to concede its legal position. In these circumstances, the situation in which the United States continued after 1937 to exercise consular jurisdiction over all criminal and civil cases in which United States nationals were defendants is one that must be regarded as in the nature of a provisional situation acquiesced by the Moroccan authorities. We just be acquiescing. The Moroccan authorities, the Moroccans, the Moors, the Moorish governments, we've been acquiescing. That's all I'm reading is acquiescence. Accordingly, it is necessary to conclude that apart from the special rights under Articles 20 and 21 of the Treaty of 1836 and those which arise from the provisions of the Act of Algeciras, to which reference has been made above, the United States claims to exercise and enjoy as of right consular jurisdiction and other capitulatory rights in the French zone came to an end with the termination of all rights and privileges of a capitulatory character in the French zone of the Sharifian Empire by Great Britain in pursuance of the provisions of the Convention of 1937. Now we switch to subject matter with those 3 asterisks. Got to check my phone to make sure I'm still sharing. All right. The court will now consider the claim that United States nationals are not subjects in principle to the application of Moroccan laws unless they have first received the assent of the United States government. Okay, let's read that again. The court will now consider the claim. So this is a United States claim. The court will now consider the claim that United States nationals are not subject in principle. And you see here, United States nationals, they're not talking about Moorish nationals, they're talking about their own citizens. So it says the court will now consider the claim that United States nationals are not subject in principle to the application of Moroccan laws unless they have first received the assent of the United States government. In other words, we got to get permission from them to get them to impose our Moroccan laws on them. What sense does that make? The French submission in this regard reads as follows: that the government of the United States of America is not entitled to claim that the application of all laws and regulations to its nationals in Morocco requires its express consent. That's true, France. That the nationals of the United States of America and Morocco are subject to the laws and regulations in force in the Sharifian Empire, and in particular, the regulation of December 30th, 1948 on imports not involving an allocation of currency without the prior consent of the United States government. The United States submission in this regard reads as follows. So this is what the United States is now saying. Under the regime of extraterritorial jurisdiction now exercised by the United States in Morocco. So the United States, this is what the United States is saying. Under the regime of extraterritorial jurisdiction now exercised by the United States in Morocco. So, they exposed themselves in this case. United States citizens are not subject in principle to the application of Moroccan laws. Yeah, right. Such laws become applicable to the United States citizen only if they are submitted to the prior assent of the United States government and if this government agrees to make them applicable to its citizens. Really? You got some nerves the year of December 30th, 1948, not having been submitted to the prior assent of the United States government cannot be made applicable to the United States citizens. So then here comes the court. The claim that Moroccan laws are not binding on the United States nationals, unless assented to by the government of the United States, is linked with the regime of capitulations, and it will not be necessary to repeat the considerations which have already been discussed in dealing with consular jurisdiction. There is no provision in any of the treaties which have been under consideration in this case conferring upon the United States any such right. The so-called, quote unquote, right of assent is merely a corollary of the system of consular jurisdiction. The consular courts applied their own law and they were not bound in any way by Moroccan law or Moroccan legislation. Moroccan legislation. We got a master legislation, AMPAG officials. Before a consular court could give effect to a Moroccan law, it was necessary for the foreign power concerned to provide for its adoption as a law binding on the consul in his judicial capacity. All right, let's read that again. Before a consular court could give effect to a Moroccan law, it was necessary for the foreign power concerned to provide for its adoption as a law binding on the consul in his judicial capacity. It was the unusual practice to do this by embodying by embodying it either in the legislation of the foreign state or in ministerial or consular decrees of that state issued in pursuance of delegated powers. This is saying that they have to write legislation to support Moroccan law within their state. So we have a no mask mandate, or a no mandate in general, or a plant-based, what was that one? Plant-based medicine. We got a couple of legislations that we're working on. So let's say the no mandate legislation. Once our legislation is enacted, consular court will send out a judicial order to the colonizers, letting them know of our legislation, but also giving them orders to establish legislation within their state to support the legislations within our state, if that makes any sense. If you all understand what I'm saying. So we have a legislation that says that we are not subject to any type of mandates. We send them a consular court order, letting them know that they have to write a legislation within their state that says that we don't have to take the mandates. So there's two legislations that says we don't have to take mandates. Legislation coming from our state and the legislation coming from their state. In other words, the legislation that's coming from their state is telling their officials to leave these Moors alone. They're not subject to any mandates. That's the name of the game. And that process hasn't been exercised. They are operating under customs and usage. They're so used to us being in acquiescence mode that obviously the first few orders that get sent out, they're gonna be like, oh hell no, we can't. they're gonna try to stall and back out of that. They're not gonna. So we got to keep beating them in the head with a pen in legislation until they soften up and start doing as they're supposed to. That's the name. That's what's going on.
And with that, and with those repeated legislations and penalties, that's right. And they keep adding up, piling up, and confiscations.
Penalties.
That's right.
They will find themselves in contempt of court. From that point, after so many attempts, based on mediation, arbitration, based on due process, based on diplomatic relations, after so many attempts, ICJ. Islam. All right. It was the unusual practice to do this by embodying it either in the legislation of the foreign state or in the ministerial or court consular decrees of that state issued in pursuance of the delegated powers. The foreign state, United States, could have this done or it could refuse to provide for the enforcement of the law. There was a right of assent only to the extent that the intervention of the consular court was necessary to secure the effective enforcement of a Moroccan law as against the foreign nationals. In the absence of any treaty provisions dealing with this matter, it has been contended that a right of assent can be based on customs, usage, or practice. It is unnecessary to repeat the reasons which have been given for rejecting customs, usage, and practice as a basis for extended consular jurisdiction, and which are largely applicable to the right of assent. It is, however, necessary to point out that the very large number of instances in which Moroccan laws were referred to the United States authorities can readily be explained as a convenient way of ensuring their incorporation in ministerial decrees binding upon the consular courts. In that way, and in that way only, could these laws be made enforceable as against United States nationals, so long as the extended consular jurisdiction was being exercised. It's only one way, consular court. Let me read that again. It is, however, necessary to point out that the very large number of instances in which Moroccan laws were referred to the United States authorities can readily be explained as a convenient way of ensuring their incorporation in ministerial decrees binding upon consular court. In that way, and in that way only, could these laws be made enforceable against United States nationals so long as the extended consular jurisdiction was being exercised. There's only one way to make our Moroccan laws binding against the United States and its nationals and its citizens. And that's only so long as the extended consular jurisdiction was being exercised. Everywhere you turn, starting in 1787, with Article 20 of the Treaty of Peace and Friendship, it tells you consular court is the Supreme Court. Everything dealing with these foreigners goes through consular court. So what did Prophet Noble Drew Ali say? That we need to stay out of their courts. How do you stay out of the courts? Exercising consular court. That's it. You can't tell me that Prophet Noble Drew Ali was not an international jurist who was reading and studying and understanding these treaties and international law in general. So why would a Moor, so-called Grand Sheikh, would tell me that divine law trumps treaty law all day? When that divine law that he's talking about is this, the Circle 7 Quran that came out in 1913, when the treaty came out in 1787. Long before the prophet even. The incompetence is real. Wow. The problem arises in three ways, which must be considered separately. The first is in cases where the application of a Moroccan law to United States nationals would be contrary to the treaty rights of the United States. In such cases, the application of Moroccan laws, whether directly or indirectly to these nationals, unless ascended to by the United States, will be contrary to international law. Contrary to international law. Contrary to international law. That would be contrary. What are you talking about? That we require the right of assent. We need your permission for you to make our laws, Moroccan laws, binding upon you. Yet your authority for your existence here on this land is through our treaties. That's like saying, that's like the tenant telling the landlord that the landlord requires the permission of the tenant for the landlord to exercise the contract agreement against the tenant. What? The United States is off the chain. And the dispute which might arise therefrom would have to be dealt with according to the ordinary methods for the settlement of international disputes. These considerations apply to the decree of December 30th, 1948, which the court has found to be contrary to treaty rights of the United States. The second way in which the problem arises is in cases in which the cooperation of the consular courts is required in order to enforce the Moroccan legislation. The second way in which the problem arises in cases in which the cooperation of the consular courts is required in order to enforce the Moroccan legislation. In such cases, regardless of whether the application of the legislation would contravene treaty rights, the assent of the United States would be essential to its enforcement by the consular courts. The third way in which the problem arises is in cases where the application of the United States nationals, otherwise than by enforcement through the consular courts of Moroccan laws which do not violate any treaty rights of the United States, is in question. In such cases, the assent of the United States authorities is not required. So you can't make laws from consular court that would violate the United States treaty rights, right? So it has to be in conformity with the treaties, but they still have to abide by it. Accordingly, and subject to the foregoing qualifications, the court holds that the United States is not entitled to claim that the application of laws and regulations to its nationals in the French zone requires its assent. Accordingly, subject to the foregoing qualifications, the ICJ, the court, holds that the United States is not entitled to claim that the application of laws and regulations to its nationals in the French zone requires its assent. Sit down, United States, with that foolishness. All right, the government of the United States of America has submitted a counterclaim, a part of which relates to the question of immunity from Moroccan taxes in general, really, and particularly from the consumption taxes provided by the Sharifian Dahir of February 28, 1948. The following submissions are presented with regard to these questions. On behalf of the government of the United States. 2, the treaties exempt American nationals from taxes, except as specifically provided by the same treaties, to collect taxes from American nationals in violation of the terms of the treaties is a breach of international law. This is the United States talking. Such taxes can legally be collected from American nationals only with the previous consent of the United States, which operates to waive temporarily its treaty right, and from the date upon which such consent is given, unless otherwise specified by the terms of the consent. In this section here, I believe they're referring to the French trying to force the United States to pay taxes, which is not their, what's the word I'm looking for? They're outside. No, it's not their authority, the French authority. The French can't request or demand taxes out of the United States because both of you are on the subordinate side of the tax, of the, of the contract.
Yeah, yeah.
So what you doing trying to force the United States to pay taxes when you supposed to be paying taxes too?
Yeah.
Only people that can charge taxes are the Moroccans. So such taxes can legally be collected, I already read that. Consumption taxes provided by the, did I already read that as well? Let me read it again anyway. Consumption taxes provided by the Dahir of February 28, 1948, which were collected from American nationals up to, so they had been collecting taxes from them, up to August 13, 1950, the date on which the United States consented to these taxes were illegally collected and should be refunded to them. So they, so they did pay the taxes and they want a refund. 3, since Moroccan laws do not become applicable to American citizens until they have received the prior assent of the United States government, the lack of assent of the United States government to the day of February 28, 1948, rendered illegal the collection of the consumption taxes provided by that Dahir. That's the United States talking. On behalf of the government of France, that no treaty has conferred on the United States fiscal immunity for its nationals in Morocco. That no treaty has conferred on the United States fiscal immunities for its nationals in Morocco. That no treaty has conferred on the United States fiscal immunity for its nationals in Morocco, either directly or through the effect of the most favored nation clause. That the laws and regulations on fiscal matters which have been put into force in the Sharifian Empire are applicable to the nationals of the United States without the prior consent of the government of the United States. That consequently, consumption taxes provided by the Dahir of February 28, 1948 have been legally collected from the nationals of the United States and should not be refunded to them. They're going back, they're going at it. And what are they using? Moroccan laws, what are they using? The supreme law of the land, what is that? Treaties, what is it not? Circles happen. Nobody in the international community, not even the ICJ, which are the highest level of judges, use this document. So how does this trump treaty law? Moors, we really got to start thinking and studying, and I don't know. I guess it's just not for everybody, right? We just got to work with those who got the eyes to see and the ears to hear. Those who are dumb, deaf, and blind, leave them alone. The 85ers, we're only dealing with 5%. Those who got the eyes to see and the ears to hear. And it's frustrating, but it is what it is. And it doesn't require all of us to make this thing happen anyway, right? Anyway, the government of the United States contends that its treaty rights in Morocco confer upon United States nationals an immunity from taxes, except the taxes specifically recognized and permitted by the treaties. And let me say this. This is not a disrespect towards the prophet in his literature. I'm just saying, it's just not, this doesn't trump treaty law. It just doesn't. No disrespect to the prophet and what he put together, but it doesn't. These things were here before the prophet even came here. He didn't start this stuff. He didn't make up fezzes. He didn't make up the flag. He didn't make up bay ales or anything like that. He brought it back. He brought it back into our consciousness. All these things were already here before the prophet even came. This wasn't even authored by the prophet. Do y'all want me to read it? Okay, I'll read it, even if you don't want me to. It says right here, divinely prepared. This is a compilation of other documents that he just put together for our salvation. He didn't even write this. These are all old information. This is all old documents and information that he put together as a compilation to create the Circle 7. It says it right there. Divinely prepared by noble Jew by the noble prophet, noble Jew. Y'all got to stop this worshiping crap. The prophet said it. Don't worship me. Study and carry on my laws. Carry on my laws meaning what? Extend upon it. Carry it on to the next degrees, because the other half hasn't been told. And if I did tell you the other half, all I'm gonna do is put you back to sleep. Because in 1913, Negroes, blacks, and coloreds who were in darkness, mental darkness, couldn't even conceive of their true nationality, far less that they're supposed to be running governments. So if I'm having problems getting the NBCs into the mindset of their ancient foremothers and forefathers, if that's a problem, what do you think is going to happen if I take them from there all the way into statehood? Man, they'll just go right back to sleep. That's why he said this is for 100 years, for the next generation, 100 years later. So when they say that the Moors will come into their own in the year 2000, in the years, the millennium, it doesn't mean the year 2000 specifically. We're really not coming into our own till now. 2021, the first state that established their state in conformity with international law by ratifying, depositing, and promulgating their constitution. That was Allodium Moris Paradium Ante Colorado. Then came New Mecca, then came AMPAG, following those principles as it relates to international law. Not following J-Bay, following the teachings and the instructions that's contained within international law, as you see I'm reading right now, and as you see me going over in the previous classes. That's the reference point. The reference point is not J-Bay. He highlighted and referenced those reference points for our further erudition in the matter to identify it to be so or not. Study to make yourself approved. So you go back and you read these things, it's like, oh, wow, the brother was right. You didn't make any of this stuff up. The Act of France, this case that we're going over is in 1952. And all of his discussion takes place, is dealing with matters that took place prior to 1952, which means J-Bay wasn't even alive then. So it's not coming from him. We all know that treaties are the supreme law of the land. The colonizers told us that. So why are we ignoring it? Why do you choose to study municipal laws instead? Okay, so we've mastered it. It's time to move on. It's time to move on to the higher degrees. What are the higher degrees? Treaty law, international law. Oh, Moors, like the prophet said, Moors, you are hard-headed people. The government of the United States contends that its treaty rights in Morocco confer upon United States nationals an immunity from taxes exempt to except the taxes specifically recognized and permitted by the treaties. This contention is based on certain bilateral treaties with Morocco, as well as on the Madrid Convention of 1880 and the Act of Algeciras of 1906. The court will first consider the contention that the right to fiscal immunity can be derived from the most favored nation clauses in Article 24 of the treaty between the United States and Morocco of 1836, and in Article 17 of the Madrid Convention, in conjunction with certain provisions and treaties between Morocco and Great Britain and Morocco and Spain. The General Treaty between Great Britain and Morocco of 1956 provided in the second paragraph of Article 4 that British subjects shall not be obligated to pay under any pretense whatever any taxes or impositions. The treaty between Morocco and Spain of 1861 provided in Article 5 that Spanish subjects cannot under any pretext be forced to pay taxes or contributions. It is submitted on behalf of the United States that the most favored nation clauses in treaties with countries like Morocco were not intended to create merely temporary or dependent rights, but were intended to incorporate permanently these rights and render them independent of the treaties by which they were originally accorded. It is consequently contended that the right to fiscal immunity accorded by the British General Treaty of 1856 and the Spanish Treaty of 1861 was incorporated in the treaties which guaranteed to the United States most favored nation treatment, with the result that this right would continue even if the rights and privileges granted by the treaties of 1856 and 1861 should come to an end. For the reason stated above in connection with consular jurisdiction, the court is unable to accept this contention. It is not established that most favored nation clauses in treaties with Morocco have a meaning in effect other than such clauses in other treaties or are governed by different rules of law. When provisions granting fiscal immunity in treaties between Morocco and third states have been abrogated or renounced, these provisions can no longer be relied upon by virtue of a most favored nation clause. In such circumstances, it becomes necessary to examine whether the above mentioned provision in the treaties of 1856 and 1861 are still in force. The second paragraph of Article 4 in the General Treaty with Great Britain was abrogated by the Franco-British Convention of July 29, 1937. Protocol of Signature, Article 4A, as from the coming into force of this convention, that paragraph of Article 4 of the General Treaty of 1856 could no longer be relied upon by the United States by virtue of a most favored nation clause. As already held above, the effect of the declaration made by France and Spain of March 7, 1914 was an unconditional renunciation by Spain of all the rights and privileges arising out of the regime of capitulations in the French zone. This renunciation involved, in the opinion of the court, a renunciation by Spain of the right of its nationals to immunity from taxes under Article 5 of its treaty with Morocco of 1861. Since such a general and complete immunity from taxes must be considered as an element of the regime of capitulations in Morocco. When Spain relinquished all the capitulatory rights, it must thereby be considered as having given up the right of fiscal immunity. This view is confirmed by the attitude taken by number of other states in this respect. Great Britain renounced all rights and privileges of a capitulatory character in the French zone by Article 1 of its convention with France of 1937. In the Protocol of Signature, it was declared that the effect of this article and of Article 16 is to abrogate a number of articles in the General Treaty of 1856, including, as has been stated above, the second paragraph of Article 4. This seems to show that France, representing Morocco and Great Britain, were proceeding on the assumption that the tax immunity accorded by that article was a right of a capitulatory character. The other states, which during the years 1914 and 1916, equally renounced all rights and privileges arising out of the regime of capitulations in the French zone, have acquiesced in the taxation of their nationals. For these reasons, the court holds that the right to tax immunity accorded by Article 5 of the Spanish Treaty of 1861, having been surrendered by Spain, can no longer be invoked by the United States by virtue of a most favored nation clause. The government of the United States has further contended that it has an independent claim to tax immunity by virtue of being a party to the Convention of Madrid and the Act of Algeciras. It contends that by these instruments, a regime as to taxes was set up, which continued the tax immunity in favor, and look how they spell favor, F-A-V-O-U-R, that's the French form of favor, of the nationals of foreign states, thereby confirming and incorporating the pre-existing regime, which therefore is still in force, except for the states which have agreed to give it up. The court is, however, of opinion that the Madrid Convention did not confirm and incorporate the then existing principle of tax immunity. It merely presupposed the existence of this principle and curtailed it by exceptions in Article 12 and 13 without modifying its legal basis. It did not provide a new and independent ground for any claim of tax immunity. Similar considerations apply to the Act of Algeciras, which further curtailed the regime of tax immunity by exceptions of Articles 59, 61, 64, and 65. It did not provide any new and independent legal basis for exemption from taxes. The government of the United States has invoked Article 2 and 3 of the Madrid Convention, which grant exemptions from taxes other than those mentioned in Article 12 and 13 to certain protected persons. That's that protected persons list. But the proteges, mentioned in Article 2 and 3 constituted only a limited class of persons in the service of diplomatic representatives and consuls of foreign states. No conclusion as to tax immunity for nationals of the United States in general can, in the opinion of the court, be drawn from the privileges granted to this limited class of protected persons. It's like, yeah, United States, you trying it, you gotta pay taxes. It is finally contended on behalf of the government of the United States that the consumption taxes imposed by the decree of February 28, 1948 are in contravention of special treaty rights. Reference is made to the Treaty of Commerce between Great Britain and Morocco of 1856, Articles 3, 7, 8, and 9. And it is submitted that United States nationals are exempt from those consumption taxes by virtue of these articles in conjunction with the most favored nation clauses in the Treaty of 1836 between Morocco and the United States. These four, and you see, like even the ICJ, like, I don't know why, they don't read it properly. This ain't even due to indoctrination or brainwashing, it's due to miseducation. Like, more don't know how to read. I had the more tell me on Facebook, I put a post and his response to the post was that, I was saying that the Treaty of Peace and Friendship is between the Americans and the Moroccans. We are the Americans. I mean, we are the Moroccans, they are the Moroccans. They are the Americans. He responded to me by saying that we are both. Now, this is what a regular fez-wearing Negro said. What did the ICJ say? The ICJ just said right here, the Treaty of 1836 between Morocco and the United States. The Treaty of Peace and Friendship of 1836 between Morocco and the United States. The international jurist is telling you that it's between two different nations. If you read just the title, you ain't got to read the whole thing. Just read the title. It says that the treaty is between the United States of America and the Sultan of Morocco, or between Morocco and the United States of America. So why did this U.S.A citizen, this guy was a U.S.A citizen, why would he say that we are both? Why? Because, Moors are under the impression that they are both. How are they both? Based on their free, what they consider or think is their free national name. What is that? Moorish American. You're not, you can't be both. You have the dominant side, which is the, my phone died, which is the Moorish side, which is the Moroccan side. You're not a part of the American side of it. You got to choose between which side of the table are you going to sit on, good brother? You can't just sit in the middle. Like, they said it right here. The treaty is between Morocco and the United States. These 4 articles in the British Commercial Treaty of 1856 relate to taxes and duties on goods exported from or imported into Morocco, or on goods conveyed from one Moroccan port to another. The consumption taxes provided by the Dahir of February 28, 1948 are, according to its Article 8, payable on all products, whether they are imported into the French zone of Morocco or manufactured or produced there. They cannot therefore be assimilated to the particular taxes mentioned in the articles of the British Commercial Treaty invoked by the United States, nor can they be considered as a customs duty. The mere fact that it may be convenient in the case of imported goods to collect the consumption tax at the customs office does not alter its essential character as a tax levied upon all goods, whether imported onto or produced in Morocco. It may be recalled in this connection that the Permanent Court of International Justice recognized that fiscal duties collected at the frontier on the entry of certain goods were not to be confused with customs duties. It is in its judgment of June 7, 1932, in the Free Zones case, PCIJ series case law, it laid down that the withdrawal of the customs line does not affect the right of the French government to collect at the political frontier fiscal duties not possessing the character of custom duties. The court is consequently unable to hold that the imposition of these consumption taxes contravenes any treaty rights of the United States. In such circumstances, the question of a partial refund of consumption taxes paid by the United States nationals does not arise. It follows from the above mentioned consideration that the government of the United States is not entitled to claim that taxes, including consumption taxes, shall be submitted to the previous consent of that government before they can legally be collected from nationals of the United States, since they are, in the opinion of the court, not exempt from the payment of any taxes in the French zone. There is no legal basis for the claim that laws and regulations on fiscal matters shall be submitted to the United States authorities for approval. The conclusion which the court has thus arrived at seems to be in accordance with the attitude which other states have taken with regard to this question. Tax immunity in the French zone is not claimed either by the United Kingdom or by Spain or any other state which previously enjoyed such a privileged position. The only state now claiming this privilege is the United States. Though no tax immunity is guaranteed by its treaty with Morocco of 1836. The only state now claiming this privilege is the United States, though no tax immunity is guaranteed by its treaty with Morocco of 1836. They got some nerves. Let me repeat that again. The only state now claiming the privilege is the United States, though no tax immunity is guaranteed by its treaty with Morocco of 1836. To recognize tax immunity for United States nationals alone would not be compatible with the principle of equality of treatment in economic matters on which the Act of Algeciras is based. So pay your taxes and shut up. Sit down somewhere. The final submission of the United States of America upon that part of its counterclaim, which is based upon Article 95 of the General Act of Algeciras, is as follows. 1, under Article 95 of the Act of Algeciras, the value of imports from the United States must be determined for the purpose of custom assessments by adding to the purchase value of the imported merchandise in the United States the express incidental to its transportation to the custom house in Morocco, exclusive of all expenses following its delivery to the custom house, such as customs duties and storage fees. It is a violation of the Act of Algeciras and a breach of international law for the customs authorities to depart from the method of valuation so defined and to determine the value of imported merchandise for customs purposes by relying on the value of the imported merchandise on the local Moroccan market. The final submission of the government of France upon this part of the counterclaim is as follows. That Article 95 of the Act of Algeciras defines value for custom purposes as the value of the merchandise at the time and at the place where it is presented for custom clearance, which as was made clear in the oral argument, means the value in the local, i.e. Moroccan market. Oh, and by the way, anyone who may have their hands up, I cannot see it. So if you got any questions, just come on in and ask your questions. I'm gonna try to end it at around, it's 9:05, I'm gonna try to end this particular reading at 9:30. I really was hoping that I could finish it. I don't really wanna have a part 4, but if we have to, then we have to. We'll take our time. There's no sense in rushing through it. But I do have a few other things I want to go over. All right, the necessity evidenced by Article 95, 96, and 97 of the Act of Algeciras of creating some kind of machinery for securing a just valuation of goods by the customs authorities would appear to follow inter alia, A, from the principle of economic equality, which is one of the principles underlying the acts, right? They're talking about economic liberty without any inequality. So they just said economic equality. And B, from the fact, now check this out, and B, from the fact that the import duties were fixed by the signatory powers at 12.5%. They got to pay 12.5%. Clearly, it would be easy if it were desired to do so, to discriminate against particular importers by means of arbitrary valuations or to evade a fixed limitation of duties by means of inflated valuations. But while the signatory powers realize the necessity for some such machinery, it does not appear that the machinery has given rise to a practice which has been consistently followed since the act entered into force. Article 95 specifies 4 factors in valuating merchandise. A, the valuation must be based upon its cash wholesale value. B, the time and place of the valuation are fixed at the entry of the merchandise at the customs house. C, the merchandise must be valued free from customs duties and storage dues. That is to say, the value must not include these charges. And D, the valuation must take account of depreciation resulting from damage, if any. Article 96, which relates only to the principal goods taxed by the Moorish Customs Administration, contemplated an annual fixing of value by a committee on customs valuations, sitting at Tangier. The local character of this committee and of the persons whom it is directed to consult should be noted. The schedule of values fixed by it was to be subject to provision at the end of 6 months if any considerable changes had taken place in the value of certain goods. Article 96 is procedural and is intended to operate within the ambit of Article 95. Article 97 provided for the establishment of a permanent committee of customs intended to supervise the customs service on a high level and to watch over the application of Article 96 and 97, subject to the advice and consent of the diplomatic body at Tangier. The Committee on Customs Valuations referred to in Article 96 appears to have lapsed in 1924. Prophet Waziralrais was still alive when the Convention of December 18th, 1923, on the Tangier zone came into force and replaced it by a committee representing the 3 zones. The latter committee has not met since 1936. All right. Articles 82 to 86 of the Act, which relate to declarations by importers, must also be noted. Article 82 requires an importer to file a declaration which must contain a detailed statement setting forth the nature, quality, weight, number, measurement, and value of the merchandise, as well as the nature, marks, and numbers of the packages containing the same. I mean, this stuff is like organized. Very well organized. A declaration of value made by the importer can clearly not be decisive because he is an interested party, but at the same time, he knows more about the goods than anybody else. And unless fraud is suspected, it is right that the value appearing in the declaration should form an important element in the valuation about to be made. It cannot be said that the provisions of Article 95 alone or of Chapter 5 of the Act considering as a whole afford decisive evidence in support of either of the interpretations contended for by the parties respectively. The 4 factors specified by Article 95 are consistent with either interpretation. In particular, the expression free from customs duties and storage dues affords no clear indication, because if the value of the country of origin increased by the amount of insurance, freight, etc., is to be taken as the basis, this expression means before entering the customs office and paying duties. Whereas if the value in the local market is to be accepted as the basis, some such expressions is necessary, or at any rate, prudent, in order to indicate that the duty of 12.5% must not be levied on a value which already contains the 12.5%. The court has examined the earlier practice, and that here we go, one of these words, preparatory work of the Conference of Algiers in 1906, but not much guidance is obtainable from these sources. The commercial agreement made between France and Morocco, dated October 4th, 1892, consists of 2 letters exchanged between the foreign minister of Morocco and the minister of France and Morocco, the latter of which contains the expression, "These goods shall be assessed on the basis of their cash wholesale market value in the port of discharge in reals of vellon." We're gonna have to look that word up. A preliminary draft, and I'm gonna do my best too, by the way, to get these classes on VHS and DVD for some people out there that, you know, the old Moors who won't learn new tricks. A preliminary draft of the Act, page 97 of French documents, diplomatiques, like French, contains the following article. Article, what's that? 10, that's what? 14? No, 19. Article 19, import and export duties shall be paid forthwith in cash at the custom house where clearance is effected. The ad valorem duties shall be determined and paid on the basis of the cash wholesale value of the goods at the port of discharge on the custom house. In the case of imports, merchandise can only be removed after the payment of custom duties and storage. The holding of the goods or the collection of duty shall in every case be made the subject of a regular receipt delivered by the officer in charge. Later, page 100, upon a British proposal, the second sentence was modified so as to read, the ad valorem duties shall be determined and paid on the basis of the cash wholesale value of the goods at the custom house, free from custom duties. At a later stage, the German delegation made the following proposal. Page 232. The ad valorem duties imposed on imports in Morocco shall be assessed on the value of the imported goods in the place of shipment or of purchase, to which shall be added the transport and insurance charges to the port of discharge in Morocco. So this is dealing with our ports. We're supposed to have Moorish port authorities checking out certificate of manifest and charging foreigners different types of fees and duties and taxes for bringing merchandise into our land. We got a long way to go. We got a lot to create, to not recreate, we just really take over the system, really. And if it's a Caucasian working the ports, then that Caucasian is working for or on behalf of or an employee of the Moorish Customs House or any other nationality. Because remember, there cannot be any inequality. It is called economic liberty without any inequality, or economic liberty with full equality. Right now, that doesn't mean that everybody get the same number, the same amount. I mean, all the financial aspect goes to the Moroccan governments, but any contractor that assists in the operation of such system, everything has got to be based on in equality. But what we see is something opposite of it. So currently, you will see a Moor working as a customs authority, but he's working on behalf of the foreign power, because the foreign power is the one who has the authority currently in these operations. And they're the ones that's collecting all the taxes and dues and fees. So please share this information, share this video. Because if Moors want to do something better for themselves and their posterity, then that which needs to be done is establish your governments and take the system back over. But one thing that's plaguing the so-called Black community, the Moorish community, is laziness and also incompetence. But the main foundation of it all is lack of knowledge. So what happens to our people because of a lack of knowledge? What happens to the people for a lack of knowledge? They perish. This is the knowledge that we need. This is the information that we need. These are the instructions that we need. And these are the instructions and knowledge and information that has been kept from us by all of our leader guys who have taken a death oath to not reveal these secrets. So what they talk about, the Illuminati secrets, the Freemason secrets. What is it? New World Order? FEMA camps, all these fear mongering tactics of world control. This is where they have our minds at. They used to say that the pyramid on the back of the dollar bill represent the Illuminati, and not the illuminated ones as us, but the Illuminati's like Rothschilds and them, like the evil guys who want to eat children and just enslave everybody. This is what we're under the impression that's the secret. Well, if it was so secret, then how was it out there? That's why it wasn't a secret. Those were conspiracy theories the whole time. But when they say it's a conspiracy theory, more than likely it was a conspiracy theory in hindsight. That's not the concern. Those weren't the issues. The real concern and the real issue is don't let these Negroes get back to government. So let's pump out a bunch of misinformation. The pyramid is the Illuminati. The United Nations is the Rothschilds and the Rockefellers. This type of thing. And then put them in the mindset of working within municipal laws. Name it, it doesn't matter. From UCCs to U.S.A. codes, it doesn't matter. I don't care about their laws. We should not care about anything dealing with them. I don't care what you, Moors think that we got to rescind contracts and do all these things and the birth certificate and the social security and there's contracts there we got to rescind. That's a bunch of BS. That's
also keep busy work.
That's also what?
It's kind of like give them something to keep them occupied.
Yeah.
Yeah. Mm-hmm.
Because at the end of the day, we have to remember, if we are the Moroccans, this is our land, and we are the landlords, and we have the authority over all things dealing with Morocco, why do I care about rescinding anything? That's their procedures within their jurisdiction. We are talking about sovereignty and independence, autonomy. Separate, totally separate, while at the same time exercising authority over them as who? The landlords of what? The land in which they exist upon. So why do I care about rescinding anything? We shouldn't care about any process. The only time you should be concerned about that is if you plan on staying within their jurisdiction. As long as you're in their jurisdiction as ipso mori subjects, then yeah, you might need to finesse those processes, master it and finesse it to your advantage and to your benefit. But that's not what this movement is about. That's not what international law and statehood is all about. That's not what that's about. It is about you establishing your legislation, your laws within your state, and you in controlling and governing them. We got to get out of the mindset of being governed as minorities, as adopted children who always need protection from all other foreign entities. We got to get out of this reliance on them. We rely on them too much. It's like we're the fathers and the mothers, but we're dependent on them as if they're the fathers and they're the mothers. It's sickening. It's absolutely sickening. Moors will argue you down about processes, United States processes. It's like, man, listen, bro. The name of the game is write your own laws. And when I read these things, I get frustrated, man. When I read these things, and in hindsight, as I'm reading, I'm thinking back on other conversations and debates and stuff, especially since I came into this knowledge of international law. The debate is always, well, we got to rescind contracts and we can't do this, we can't. I tell them more about the national trust bringing things into the national. Oh, we can't bring nothing into the national, into no national trust until we rescind the contract. Like, brother, if we're talking about remaining within their system, okay, you got that. But that's not the discussion. The discussion is autonomy. The discussion is sovereignty and independence. The discussion is total separation, while at the same time exercising our authority over them through what? Consular court and legislation. We got to tell them what to do, not continue with this mindset and this energy and this vibe of them telling us what to do, and we got to follow along with their process and their system, whatever you think you discovered, because some guy, like there's this one famous YouTuber guy, I don't mean to call out names, but it is what it is. You know, you got this guy like, you know, U.S.A, for example. I don't care about those internal processes. You want to talk about private versus public? Private is nationals of their own states with their own laws and legislation that's governing these colonizers. That's private. Don't tell me about private within their system, because the goal is to choose between entire submission to the laws of the empire. Either you're gonna remain in American jurisdiction, or you're gonna exit out of American jurisdiction and go into the Moroccan jurisdiction, which is the rock of salvation. And how do you do that? One of two ways. Either you consent to a Moorish state government, and if there's not one in existence, then you establish a competent Moorish state government, as we have done here with AMPAG, because that is the current name of this land. The chartered colony of the state of Georgia, that's dead. The new name of this land is AMPAG, Allodium Moorish Palladium, Ante, Georgia, which again, by the way, it means free Moorish estates before Georgia. The name in it of itself is a slap in the colonizer's face. Free Moorish estates before the existence of anything named some damn Georgia. So don't misconstrue the name and just use Georgia and just run with that as if we named the state Georgia. You got some ignorant Moors out here doing that as well. Read the whole name of the state and examine the definition so that you'll know exactly what you're talking about, fool. It is Allodium Moorish Palladium Ante, Georgia. Translation: free Moorish estates before Georgia. Allodium Moorish Palladium Ante, Colorado. Free Moorish estates before Colorado. Don't put up on your screen the word Colorado and break down that it means color as if the Moors chose that as the name of their state. That's ignorance and absolute incompetence. Ante Colorado means before Colorado. And you're supposed to be a Grand Sheik. But of course, if you're stuck on VHSs and DVDs, then obviously you're an old dog and you cannot teach new tricks to old dogs, which is why the prophet said to put the old dogs in the back. Because they're not going to do anything but cause confusion and get in the damn way of progress, like J. Jermaine Bay would say. Lead, follow, or get the hell out the way. So all these so-called exposing videos, get the hell out the way, because you don't know what you're talking about. This stuff frustrates me when I read it and I think back on other discussions with other Moors and crap that they be saying, yo, it's just, and I got to charge my phone. I really need to run and grab my charger, but I don't want to put a pause on the meeting, on the roundtable session. Let me try to finish this one up. In fact, I got to charge my phone. If you all would please, if you don't mind, give me 2 minutes. I'll be right back, you all. Discuss things amongst yourself, I suppose. I'll be right back. Give me 2 minutes. All righty, I'm back. Sorry about that. Thanks for your patience. But yes, you know, they have the clear, clean water that it once was is now muddy, and which is, you know, is muddy and is just dirty and murky. Why? Because of the three-way split. You know, oh, the reincarnated prophet. There was a crescent and a moon and a crescent found in his eyes when he passed out. You know, people follow that. Or the other guy who said that the prophet gave him the authority, and then you got a third. So who's right? Man, I just stick with international law. It's in here. This is all we need right here, man. That amendment was rejected, from which it may be inferred that the value is in the country of origin, rejected at the conclusive test. It is also necessary to examine the practice of the customs authorities since 1906, insofar as it appears from the materials made available to the court by the parties. It seems that there has been a reluctance to attribute a decisive effect to any single factor in valuing merchandise. For instance, in a letter of July 6th, first of all, can you all still hear me and we still have the screen up and everything? Just some feedback.
Islam.
Can you still hear me and you can see the screen and everything?
Islam, continue.
Okay, good. For instance, in a letter of July 6, 1912, from the controller of Moroccan customs to the American minister at Tangier, it is stated that the customs officers apply for the appraisal of merchandise, the rules established by the Act of Algeciras and by the customs regulations. They use market prices, bills of sale, and their professional knowledge. The following excerpts occur later in the same letter. The bill of sale is an element of valuation, but it is not conclusive evidence. The customs has always proceeded as described above in regard to petroleum products, oil, imported from Fiume, and from Trieste, for which importers furnish means of appraisal by attaching to the declaration the original bills of sale, of which the prices are compared with the market prices of origin. This value, i.e. for customs purposes, includes the purchase price of the petroleum F.O.B. What that mean? Okay. New York increased by all expenses subsequent to the purchase, such as export duties paid to foreign customs, transportation, packing, freight, insurance, handling, unloading, etc. In short, all that contributes to make up at the moment of presentation at the customs office the cash wholesale value of the product, according to which Under Article 95 of the Act of Algeciras, the duties must be paid. Let me go back to New York. It's interesting they bringing up New York. There was another, I think it was that correspondence with the French ambassador and his Secretary of State. They mentioned something about New York before the great earthquake took place. Right when the prophet was in chapter 47, when the prophet was saying that the Moabites are the ancient, the true founders and possessors of the present Moroccan Empire. When he said present, keep in mind that was said in 1913. But the history goes back to before the great earthquake. That's why he said that the flag has been flying over here 10,000 years, which is why I don't understand why in the world we want to just cling to this American thing. It's not ancient, it's a modern term. Morocco is the most ancient term. Your prophet said it, and you're follower of you're a worshiper of the prophet, and you won't even listen to that or examine that part. But anyhow, during the time of Pangea, when it was together, Morocco in Al-Kibulan was connected to New York. Imagine that. And I just felt like throwing that out there just because I'm seeing New York and I'm wondering if there's a connection with that. Maybe not, but there is no coincidence in anything. Everything is everything. Okay. It is also interesting to note from the minutes of the meeting at Tangier of the Committee on Customs Valuation on June 7, 1933, that the Director of Customs explained that this department adopts as elements of valuation for the application of the duties concerned the invoice of origin transport costs to the port of importation, the value of the merchandise on the local market on arrival, general market price lists, and any other information which may be useful to fix the value upon which the duty is based. Duty is all they're talking about. Okay, so on the other hand, passages can be found on the customs regulations and in circulars issued by the Moroccan debt control, in which the emphasis is laid upon the value in the Moroccan market as the important factor. The latest tables of minimum and maximum values of the principal merchandise imported into Morocco, adopted by the Committee on Customs Valuations at their last meeting on March 11, 1936. At Tangier, reveal a range so great that they could only afford the most general guidance as to the actual valuation of a particular cargo or piece of merchandise. The general impression created by an examination of the relevant materials is that those responsible for the administration of the customs since the date of the Act of Algeciras have made use of all the various elements of valuation available to them, though perhaps not always in a consistent manner. We have to figure out, we have to learn the valuation process, because if we're going to take back the empire, this is going to be part of our responsibility, right? Learning how to evaluate the incoming merchandise into our ports. We got a lot to learn, man. We ain't got time to be out here arguing with each other, exposing each other, fighting each other. There's a lot to learn, and not a lot to learn. It's a lot to relearn, because it's something that we've already. And you know what's very interesting is we've got a lot of Moors in the status of NBC, mental status, not political status, but mental status, right? Mental status and political statuses are two different things. Moorish Americans have a mental status of being Moors. NBCs have a lack of that knowledge. They have no idea. But those NBCs are in position. You know, they would be like the general manager of the ports and stuff like that. You know what I mean? I mean, we've got NBCs that are in high positions, in government positions, in all different types of positions. So we have a lot of our people are aware of these processes. They've already been taught these things by the colonizers, except they taught them these principles in the mindset of a Negro, right? And so from that perspective, you know, as Carter G. Woodson say, in the miseducation of the Negro, once you have control of their minds, you don't have to do anything. They'll find their own place. So they have found their comfortable place as subjugated Moors without any understanding, understanding, or overstanding of their true nationality. So they're good. They're making 100,000 a year, whatever, working for the colonizers, thinking they came from Africa, right? But when this thing turns around, and these same NBCs realize the truth about who they really are and that we are to operate state governments, they would more than likely at some point come back home to Morocco, and we can reestablish these things with their assistance because they already have the knowledge. You understand? So there's a lot of positive that we can see in this. A lot of our people already know a lot of these they have already got these skills. In these circumstances, the court is of the opinion that Article 95 lays down no strict rule on the point in dispute. It requires an interpretation which is more flexible than either of those which are respectively contended for by the parties in this case. The court is of the opinion that it is the duty of the customs authorities in the French zone in fixing the valuation of imported goods for customs purposes to have regard to the following factors. A, the 4 factors specified by Article 95 and mentioned above. B, the contents of the declaration which the importer is required by the act to file in the customs house. C, the wholesale cash value. I don't went past 9:30. In the market of the French zone. D, the cost in the country of origin increased by the cost of loading and unloading, insurance, freight, and other charges incurred before the goods are delivered at the custom house. E, the schedule of values, if any, which may have been prepared by the Committee on Customs Valuation referred to in Article 96, or by any committee which may have been submitted, or should I say substituted, therefore, by arrangements to which France and the United States have assented expressly or by implication. F, any other factor which is required by the special circumstances of a particular consignment or kind of merchandise. The factors referred to above are not arranged in order of priority, but should operate freely within any limits that have been or may be prescribed under Article 96 of the Act. And in view of the governing principle of economic equality, the same methods must be applied without discrimination to all importations, regardless of the origin of the goods or the nationality of the importers. You see, this is what I was just saying earlier. It's all about equality across the board. There is no, what you would say, discrimination or in United States construct, racism, because racism is a construct. That's not, there is no race, there is no racism, right? That's just, and I was just so happy to see the good brother Hakeem Bey put together an excellent video. And in that video, what is it called? Who Are You? And in that video, Isaiah Thomas, old Zeke, the one of the greatest of all time point guards out here. I mean, I remember that game he played with a busted ankle and just destroyed everybody with a busted ankle. People ain't made like that no more. But anyway, you can tell that he's somehow connected with the Moroccan Temple of America, Nation of Islam. He's following along with YouTube video. I don't know, but he was dropping some stuff, you know, and it was just it's great to see. And you can best believe many of us know these things. Dame Dash, Jay-Z's old partner, he's on the record for saying, tell me about a solid movement, I'm with it. Where is it? There's Black people out here that's looking for this. But what are they getting? A bunch of BS from Moors. Paper terrorism. What is paper terrorism? Selling paperwork, $1,200, $1,500, and none of this stuff works. Like, we have a serious problem within this Moorish movement. It's but a very, very, very few who are doing things in the form, in the spirit of nobility, under love, truth, peace, freedom, and justice for real. Most of these Moors are just dirty. Wow, that's why, you know, I took a back seat. I took a back seat for 3, 4, 5 years. I wasn't fooling with this. You know, I just said, man, I guess I'm just gonna be a Negro because I'm just not gonna deal with these Moors. You know how many Moors tried to hit me for $1,200, $1,500? And I'm like, but it's the, go ahead and get your birth certificate authenticated, go to the courts and have your name changed. And I'm like, but that doesn't make any sense. Why am I doing any of that if I'm supposed to be the Arab? Why am I going to them for permission? He said, well, you know, if you do it that way, they can't reject your card because the judge affirmed it. But still, I don't even want their state IDs. How do I get my own state ID? I don't want a nationality ID from some damn website, which I already had at the time, using the AA 222141. It works until you run into a store that doesn't have the exempt button on the register. If they don't have an exempt button on the register, then they don't have a way to input AA 222141. So it does, and I don't know what is the deal with these Moors, man, but Moorish Americans with fezzes are dirtier than your average NBC. They are worse on many levels. From Sweet Daddy Grace, who operated the International House of Prayer, I don't know if you all know who that is, all the way down to the smallest insignificant Moor. We are all full of shit. Excuse my language. Or they are all full of it. When I came across the good brother J. Bay, and all this stuff was free because he says it's birthrights and it's based on nationality, all I could say was finally, in an extension, since we've already checked the boxes as well, any other Moor or state or wannabe state, for lack of a better term, that's wanting to come online, let's do this. Ain't no charge. Well, there is a charge. Your time. I don't want to do this. I don't want to help anyone do this if you're not going to put in the time to do it. The effort and the time and whatever is necessary to make it happen. I don't need FRNs. We don't need no Cash App. We don't need no Patreon. Go to my Patreon so you can get more content. Free YouTube videos. You give me a call. We can talk about it for free. All I ask is that you do it. All Brother J. Bay asks is for you to do it. All the brothers in New Mecca asks is for you to do it. That's the game. Sickening. For these reasons, the court on the submissions, and this is why I'm going over 9:30 because I'm having these sidebar comments. For these reasons, the court on the submission of the government of the French Republic unanimously rejects this submission relating to the decree of December 3rd. Does someone got something to say? Okay. Rejects his submissions relating to the decree of December. Remember, if you got something, just come on in and say it. Rejects his submissions as Sister Makara been doing. You know, she don't care. She'll jump all in on you. Rejects his submissions relating to the decree of December 30th, 1948, issued by the Resident General of the French Republic in Morocco. Unanimously finds that the United States of America is entitled by virtue of provisions of its treaty with Morocco of September 16th, 1836, to exercise in the French zone of Morocco consular jurisdiction in all disputes, civil or criminal, between citizens or proteges of the United States. So they gave it to them. They gave it to them, but why? Because there is no other authority. Order must be maintained. And without a competent authority, then there won't be any order. So, hey, by default, the United States got it. Because why? The Moroccan government, i.e. the Moors, have did what? Acquiesced. By 10 votes to 1, finds that the United States of America is also entitled by virtue of the General Act of Algeciras of April 7, 1906, to exercise in the French zone of Morocco consular jurisdiction in all cases, civil or criminal, brought against citizens or protégés of the United States to extend to the extent required by the provisions of the Act relating to consular jurisdiction. By 6 votes to 5, rejects, except as aforesaid, the submission of the United States of America concerning consular jurisdiction, unanimously finds that the United States of America is not entitled to claim. Finds that the United States of America is not entitled to claim that the application to citizens of the United States of all laws and regulations in the French zone of Morocco requires the assent of the government of the United States, but that the consular courts of the United States may refuse to apply to United States citizens laws or regulations which have not been assented to by the government of the United States. On the counterclaim of the government of the United States of America, by 6 votes to 5, rejects the submission of the United States of America relating to exemptions from taxes. In other words, pay your damn taxes. By 7 votes to 4, rejects the submission of the United States of America relating to the consumption taxes imposed by the Sharifian Tahrir of February 28, 1948. Pay your taxes. By 6 votes to 5, finds that in applying Article 95 of the General Act of Algeciras, the value of merchandise in the country of origin and its value in the local Moroccan market are both elements in the appraisal of its cash wholesale value delivered at the customs house, done in English and French, the English text being, and why English and French? Because that's the official language of the ICJ. No other language, nothing else, not Ebonics, not Spanish, not African languages, not Arabic, French and English. Done in French and English, the English, and that's in the ICJ, it's either in the charter or the ICJ statutes, one of the other. I think it's the ICJ statutes. It's only in English and Spanish, English and French. Done in English, so that means that if someone from Nigeria want to invoke treaty rights and petition the ICJ, they're gonna have to find a way to translate their Nigerian language to French or English in order to make it work. The English text being authoritative at the Peace Palace, The Hague, this 27th day of August, 1952, in 3 copies, one of which will be placed in the archives of the court, and the others will be transmitted to the government of the French Republic and to the government of the United States of America, respectively. Signed, Arnold McNair, President, E. Hambro, Registrar. And that's it. Let me see what it says here. Judge Sue Mo declares that in his opinion, the jurisdictional rights of the United States of America in the French zone of Morocco are limited to those provided in Articles 20 and 21 of its treaty with Morocco of this September 6, 1836. Limited, not full powers, and that the United States is not entitled to exercise consular jurisdiction in cases involving the application to United States citizens of those provisions of the Act of Algeciras of 1906, which for their enforcement carried certain sanctions, this is why Eisenhower relinquished disbanded consular court in 1956. The Act of Algeciras, as far as the jurisdictional clauses are concerned, was concluded on the basis of a kind of consular jurisdiction as it existed at that time in its full form and in complete uniformity among the powers in Morocco. The various provisions in referring to consular jurisdiction, competent consular authority, competent, in parentheses, competent consular authority, consular court of the defendant, etc., clearly meant that jurisdiction which was being uniformly exercised by foreign states over their respective nationals as defendants in all cases. They did not mean such limited jurisdiction as might be exercised by the United States consular courts in accordance with Article 20 of the Moroccan United States Treaty. See, Moroccan Two different ones, two different jurisdictions, two different nations, two different governments, two different authorities. You can't be both. Moors are claiming this hyphen right here. Y'all see that hyphen? That's what that's what Moorish Americans are, that hyphen right there. Moorish Americans are a hyphen. They're the ones that's in the middle, right between Moroccan and United States. Like, I'm American and I'm Moroccan, I'm Moorish American. You're neither. I mean, you're not both, you're one or the other. And you're not even American at all, you're just Moroccan. But you can choose to be American, and if you did choose to be American, I should say American, you can choose to just be American. And if you did choose to be American, you still got to get consent from a Moroccan government anyway. You can't just arbitrarily say, oh, I'm American. You still got to get permission. If you don't believe that, just go read Treaty of Madrid, Article 15. Moroccan United States Treaty of 1836 in cases involving United States citizens or proteges. Citizens or proteges. Proteges are who? The Moors only. When therefore consular jurisdiction in its full form ceased to exist in respect of all the signatory states of the Act of Algeciras, the basis for the application by the various consular tribunals of the measures of sanction provided in the Act disappeared, and the ordinary rules of international law came into play. Consequently, such sanctions should thenceforth be applied by the territorial courts in the case of United States citizens, as well as in the case of all other foreign nationals. As regards reference in the Franco-British Convention of 1937 to the jurisdictional privileges enjoyed by the United States, it must be considered as a precautionary measure on the part of France against the possibility of the refusal of the United States to relinquish such privileges. The refusal of the United States to relinquish such privileges. In any case, the rights of the United States vis-a-vis Morocco in matters of jurisdiction must be determined by their own treaty relations and cannot derive from any admission made by France on Morocco's behalf to a third party. Judge Hackworth Badawi, Judges Hackworth Badawi, Levi Cornero, and Sir Benegal Raoul, availing themselves of the right conferred on them by Article 57 of the statute, append to the judgment the common statement of their dissenting opinion. The end. And that completes the read for this case, and we've seen what the judgment was, what the judgments were. You will find the judgment on page 41 or page 213. I'm not even sure which one is the page. I just go by the little number, 41, as you see there. But at the top, you'll see 213. I'm not really sure what that means. Anyhow, so that completes the France versus United States case. Are there any questions in regards to that case or what we've read thus far? Before we go into, what time is it? Lord have mercy, it's already 9:57. I'm not gonna be able to finish. We'll just finish this up on enough. Well, that's fine. We'll finish this on another. So next Wednesday, we'll go into the French protectorate correspondence between the French ambassador and the Secretary of State. We'll finish it up. We started that last Sunday. In fact, today is Wednesday. So next Sunday, we'll finish it up next Sunday. We'll just do that. But before we do that, before I move on any further into questions or whatever, I want to touch on the, where is it? Oh, it's my internet. I wanted to show y'all, has anyone on this line ever heard of, where is the internet? Is this the internet? No. I'm getting used to this computer. That ain't it. Oh, that ain't it. I want to show you all the what is American legation? But first I'd have to pull up the internet. Downloads, post attendee, France versus USA, login. How do you identify the internet from Mac? I'm still having problems finding the internet. Like, I know what the internet looks like on Microsoft, but I don't know if there's a special icon.
It's Safari.
But
It's
I'm
been
not
a while.
using Safari though. I'm using Chrome.
Oh well, Chrome. It's a different icon, I think.
Right, but I don't see.
Is there a search bar somewhere? Oh yeah, search bar at the top, at the very top of your screen on the right. There's a search icon up there. Hit that. Okay. Just type in Chrome.
Why don't
I thought it would search your computer for whatever app you got, but
I do have, okay, I got, this is annoying, how this thing works. I might have to put, oh, there it is. This is it.
all right.
It's crazy. This Mac stuff is annoying as hell. So what is the American legation? So we go over when we discussing this document. Log in. When we discussing this document, and amongst others, especially dealing with France, they're always talking about the American legation. I don't know if there's American legation on this particular paragraph somewhere. I don't want to start reading it because I'm not going to be able to finish. I just want to look for American legation and point it out. But we'll point it out on the next call, because I'm sure you all will continue to come and you would just build on these building blocks. So American legation in Tangier. So what is a legation though? A legation is a step below an embassy, and it's operated by a minister, whereas an embassy is operated by an ambassador. The ambassador is a higher rank than a minister. So in these days, but see, the diplomatic body was operating out of Morocco Al-Kiblan, over there across the waters. Though it was still the empire, there was no kingdom at the time, right? But that's where the governing body was, the diplomatic body and delegation. Where else you see it? What's it called? The Treaty of Madrid, 1880, and even the Act of Armed Service. You'll see a lot about the diplomatic body in Tangier, or the legation in Tangier. So let's go over what is that real quick. So, and again, this is just a quick Wikipedia search, you know. Interestingly enough, I want to draw your attention to the right. Can you guys see this here, where it says coordinates? Okay, so you see this little building, not this little building, but this building, which is built on, it says here, like courtyard of the legation location, Tangier, Morocco, coordinates 35 degrees, 4702 north, and 5 degrees, 4838 west. Longitude, latitude, pointing that out for a reason. It was built in 1821. And what is the architectural style? Moorish architecture. That's what comes up when I just hover over that hyperlink. What does that say? Moorish architecture is a style within Islamic architecture, which developed in the Western Islamic world, including Al-Andalus and what is now Morocco, Algeria, and Tunisia, the Berber states. The term Moorish comes from the Western European designation of the Muslim inhabitants of these regions as Moors. But it's not, the term Moorish does not come from Western European designation. It's an ancient term. These people be trying it, what? All right, so what does it say? The Tangier American legation. Now this puts you in the mindset and the understanding of the difference between the Moroccans and the Americans. If we are the Moroccans, we don't need an American legation because we're not even Americans. Moors, please start using your heads and start really discerning, finding the discernment into in the understanding of who you really are. You're not Americans, man. Come on. You're so not Americans. You're trying to take on their identity at the same time, saying that they're trying to steal yours. Stop being stupid, Moors. The Tangier American Legation, officially the Tangier American Legation Institute for Moroccan Studies, is a building in the Medina of Tangier, Morocco, formerly the Chancellery of the United States Diplomatic Mission to Morocco. But see, currently now it's a museum. It's no longer no more, because guess what? There is no more Morocco, the empire. Formerly, well, it's in a shallow grave. It's still in existence. It's just in a shallow grave. Formerly the Chancellery of the United States Diplomatic Mission to Morocco. It was the first American public property abroad, right? And is the only U.S. national historic landmark located in a foreign country. It was the first American public property abroad, and it's abroad, where is it at? In Morocco. So the American legation is inside of Morocco. And as I said earlier, it's a step below an embassy. So if you're Moorish and an American, then if Morocco and America were one and the same, then why would America need a legation in Morocco? Come on, Moors. The legation was established on May 17, 1821, after Sultan Mohammed bin Abdallah issued a proclamation recognizing U.S. independence from Great Britain. We're not Americans. We're the Moroccans, making his nation the first to do so, recognizing the United States. The same thing Obama bragged about, Biden, Hillary Clinton. The building was gifted by the Sultan to the US government to serve as a diplomatic post, for which it served for the next 140 years. After Morocco's diplomatic capital moved to Rabat in 1956, the building served as a variety of government functions before gradually falling into neglect and disrepair. In 1976, former US diplomats established the nonprofit Tangier American Legation Museum Society to restore and preserve the structure. The site has since served as a cultural center, museum, and research library concentrating on Arabic language studies. The Tangier American Legation is considered a symbol of the historic, cultural, and diplomatic relations between the US and the Kingdom of Morocco. So now it's the kingdom. And of long-running American engagement with the wider Islamic world. In recognition of its historic and cultural importance, the site was listed on the U.S. National Register of Historic Places. Can you please mute your mics? Can you please mute your mics? In 1981, and designated a National Historic Landmark the following year, it is one of only 39 properties owned by the U.S. Department of the State listed in the register of culturally significant property. We'll go into it further. You got diplomatic history, the present, etc. But it's just to understand what is the legation, which is basically all these foreign states have legations, which is a step below an embassy. And what does an embassy do? We already know what it does. It's, it deals with foreigners. It deals with the protection of their nationals on foreign land, correct? And that's basically what the American legation is. And it also proves that you're not American. They're the ones who are Americans. As it says right here, Sultan Mohammed bin Abdallah issued a proclamation recognizing U.S. independence from Great Britain, making his nation the first to do so, and then the building was gifted by the Sultan to the United States government to serve as a diplomatic post. So for Moors to claim that they're American, then you're saying that you're not Moroccan, and that you required your independence from Great Britain. Do you see how twisted and sick that sounds when you claim to be an American? I don't care how you spell it, Amaru, Amara, whatever ancient way you think you can spell it. It's Morocco. You can say I'm Iraq, but it's Morocco. It's Morocco. You want to say I'm Iraq, you want Morocco. I yield the floor. Are there any questions, concerns, comments? I'm all ears, and let's build. And if not, we'll shut it down, because it is 10 o'clock. A good 2.5 solid hours. And I know people got jobs in the morning. But I'll give you another 3 minutes to, I know sometimes you don't even know what you want to ask. Maybe you got to think about it a little bit.
Islam. So I don't really have a question. I just wanted to say the particular Moor you were talking about earlier, don't even concern yourself with him. I'm handling him behind the scenes.
I saw something you put out there.
Yeah, I'm taking care of that.
You got to.
But he's fighting tooth and nail, though. He's not going down. He's not gonna correct himself without being beaten over the head. So
I need to see that what you have. I haven't. What did you do? What do you? I need to go on your website.
Just revealing the truth. That's all. You know, slanderers don't like truth, so
They don't like that.
That's all I got to use is truth.
That's it. That's it. And I need access. So it's on your website.
The thing I posted.
Yeah.
No, not on the website. Just on the
Telegram?
social media platform.
Okay. Because I don't have Telegram, but I see you share something on Facebook, and I couldn't stop laughing.
Yeah.
You said something like three more, one down, 2 more, 5 more to go or something. It was just funny. You be killing them. You be killing me with that art, with those graphics, bro. You do an excellent job. So keep me in the loop, because I like laughing.
It's low.
And he needs it, bro, because it's like, man, make sure you get it on VHS and DVDs too.
I'm trying. It's kind of hard to dust off all the cobwebs, but I'm trying.
It really is. It is 2022. So you'd have to find a pawn shop somewhere to find you a DVD player and a VHS player. You know what I mean? You have to find a pawn shop. Yeah. Maybe you can order it from China. Anyway, Islam, good brother. Appreciate that. Anyone else before I close out? All right. Well, this was a good build. We'll get back to it Sunday. Sunday we'll be doing the Madrid Convention, Right of Protection of Morocco, Treaty of Madrid, 1880, and we'll finish up this document, the French Protectorate correspondence with the Secretary of State and the French ambassador. It's a real fascinating read. And whenever you guys get a chance, go ahead and Google Sharifian Empire, right? And or just Google the passing of the Sharifian Empire and get that book. It's free. Watch, they're gonna probably start charging suddenly. It's free. It's a free PDF, but the PDF is probably gonna now all of a sudden cost $1,000. I mean, if they're gonna raise the price of the golden age of the Moors to 8,000, imagine, and that ain't got nothing to do. I mean, it's just talking about ancient past, and not even the passing of the Sharifian Empire deals with our recent past, as late as 1910. That's when the book was written, which is during the time of the Prophet, and it's much more. It's probably the most accurate book I've ever came across as it relates to us, who we are, our customs, etc. is the most accurate. Everything else is based in Negro colored stuff. J.A. Rogers got great books, but he still calls us Negroes in these books in some cases. Ivan Van Sertima, they came before Columbus. these are good historical accounts, but it's not as accurate in terms of the description of the people of the time, or at least in recent times, as is described in the passing of the Sharifian Empire. And we've never heard of that book. In fact, we've never even heard the term Sharifian Empire for that matter. Some have. I've heard Asir the Ducateers mention the term before, but not to any great details or anything like that. It was just like something that he kind of sort of just glossed over. He probably doesn't know the depths of it, of what it means. Maybe he does, maybe he doesn't, I'm not sure. But I come to the understanding that he started a separate type of temple that's under the temple. And it's like, okay, how many more temples and how many variations of the temples do we need? We're just doing everything else but establishing governments. It is what it is with that. But what we're doing is important for the upliftment of fallen humanity, and is just as equally as important for our posterity, our future generations. It's going to be our future generations, the children that's coming later, who's going to master this and take it to a whole nother level. And we will be taking back the planet, because the planet is Morocco. The empire is everything. But we're in the Northwest Mexum section of the empire. And as AMPAG is related, I'll tell you our location. How can I do that? Go into our website, go to our Constitution. Come on, load up. And our Constitution, in the Dominion section, tells you our specific dominion. The dominions of the Allodian Moorish Paradia Monte, Georgia include all land, air, and waterways within latitude 30.5 degrees north to 34.9 degrees north by longitude 80.8 degrees west to 85.6 degrees west. This is our specific dominions that has been reclaimed under the pre-existing and existing sovereignty of the Moroccan Empire, under what's called uti possidetis juris. It's an international law principle. I suggest you look it up. We've got to change our vernacular. We've got to start learning terms like, let's go to the treaty tab. By the way, in case anyone forgot, the good brother Hakeem Bey put this excellent website together. Excellent job. So if you go to the treaty section, you see accession contracts. You can read some of the definitions. Ascension or accession, international law. What is a seed? What is charter? Contract, right? But that's nothing. That's just covering, that's just basically the surface. There's so much more to understand and know. Treaties, international law. We've got to change our language. The prophet said, if you change the literature, you would change the people. We've got to change our vernacular. We've got to start talking treaty language. We've got to start talking international language. We've got to start asking each other certain questions. Brother, have you acceded to your treaty yet? Or have you acceded to the Treaty of Madrid treaty yet? Or have you ratified and deposited your constitution yet, good brother? Like that's the kind of conversations we need to be having. That's the kind of talk we need to be using. That's the type of lingo we need to be using. The street lingo is cool, but we need treaty lingo as well. With the treaty lingo, that changes your mindset, which then changes, it manifests into a different behavior. That's why you want to change the vernacular, because it would change the mind, and in doing so, it would change the behavior. You know, suddenly we'll be moving around as diplomats, government diplomats, right? And not just whatever people. We need, because that's who we are. We are the diplomats. We are the governors, right? Doesn't Bay mean governor? Right? Doesn't Ale means lawgiver? Well, you don't give law and you don't govern nothing from a temple seat. Temple is just a temple. So for those Moors who like to brag about the Vatican stealing the prophet's idea and created the Vatican, I urge you to look at the whole picture. The Vatican exists within the jurisdiction of Italy. So it's the Vatican and it's Italy. Divine, national. That's the movement. The Vatican is divine, and Italy is the national. Church, state, together. What does that mean? That means that the Moroccan Temple, for every Moroccan Temple of America, there should be a state. Not just the Moroccan Temple of America by itself, by itself, by itself, by itself. So currently we probably have 1,000 Moroccan Temple of Americas on this land, in this fake country called United States. Not one state government to operate in conjunction with the Moroccan Temple. And by the way, it shouldn't even be, when we do operate from that perspective, the name should change from the Moroccan Temple of America to the Moroccan Temple of Morocco, because this is Morocco, not America. I don't care what you think the prophet did or did not do. That's old news. This is 2022. It's time to upgrade and update. And the prophet said, don't worship me, study and carry on my laws. So let's carry on the law. So we're supposed to upgrade. We're supposed to update things. He passed away in 1913, and you still carrying on with the mindset of 1913. If in fact that is the correct mindset, because his documents and his information has been corrupted. So you don't know what's right and what's not. Other than, the fairs, and there's certain things that it's uncorruptible. The spiritual aspect of things, but as it relates to jurisprudence and civics, that's definitely corrupted 100%, all over the place. But as far as our divine creed and things, that's not, that's how powerful the prophet was. That stuff couldn't even be corrupted. Anyway, I'm rambling too much. I said I was going to close out. Let me go ahead and close out. If there's no other questions or concerns, then we will go ahead.
A correction. You say he passed away in 1913, 1929.
Oh, yeah. I apologize. No, 1929. Did I say? Okay, I apologize. I'm talking too much. I'm just rambling. I apologize. Thanks for the correction, good brother. 1929. Yeah, 1929. Anything else? I'm gonna stop sharing. And we will speak to each other again next Sunday, 7:30. We'll be going over the Treaty of Madrid of 1880 again, and this time it will probably make a lot more sense than it did when we did it about 2 months ago, and it wasn't even put on video either, by the way. So this will be perfect to do it, so we can get it on YouTube. So peace, love, Islam, peace, love, prosperity to all of you, and we will get back together again in the next couple of days on Sunday.
Islam was there.
Islam, Brother Shane, Islam. Peace and love. Love y'all.
Peace and love.
Peace and love. Islam. Islam.